Who's gonna read for us this year? Eh? Who's that?
Hello,
Hello? Yes, Zion Abi.
yes, sir.
Zion no.
Yes, sir.
Hello?
Yes, sir.
Are you still there, Zion?
Yes, sir.
Is there are you alone in your place where you are?
Yes, sir. I am. I am alone, sir.
There's no noise distraction.
No, sir. There's no night, sir.
Eh?
Yes, sir. There's no
Okay.
noise. Yes, sir.
You have the material?
Yes, sir. I do.
Oh my God.
Can you hear me?
Yes, I can hear you, sir.
Okay, let's go to page 50.
Okay.
So you want to look at the rights of the rights of the agent. What rights? Sorry, you want to look at the duty of the principal. The
Okay, sir.
duties
Should
of
I
the
start?
principal to the agent.
Okay.
Hold on, I will tell you. So the
Okay,
first
sir.
duty is the duty of remuneration. The principal is supposed to pay money to the agent for the work. The second duty is the duty of to reimburse indemnity. For example, if you're a lawyer, you go to court, you file a case, you pay the necessary fees in the court. The principal is supposed to pay the law. And then there's the right of lien, EN. So we're going to start for there. We said that the principal owes to the agent. The first one is the duty of remuneration. The duty of remuneration, duty of indemnity, to indemnify the principal, to indemnify the duty of remuneration. Please, if you are there, if you have your pen, you must write. I'm going to tell the woman to, you must write. For there to be a duty of remuneration, there must be unambiguous words. Where there's one of you that's somewhere and they are talking there. So apart from everybody must mute. So the first duty is duty of remuneration. Note this in the exam, that for there to be a remuneration right for the agent, the word in the agreement must be clear and unambiguous. Okay, so money, generally the words used in the agreement must say agent will collect this commission at this rate. It must be very to not get remuneration. So it must be clear and unambiguous. So for example, if the word says that the principal will pay the agent remuneration as the principal That means it's ambiguous. So what if the principal does not deem it right? What if the principal is sick? What if if the agreement says that the agent will pay remuneration as the principal fit, then it is ambiguous. The agent will not. But if it is agreed that the principal will pay the agent remuneration, however, there are
Hello, sir, we can't hear you.
Sir, I can't hear you.
We can't hear you.
so the words must be clear and unambiguous. The words used must be clear and unambiguous. The remuneration right is a commission that is due to the agent. So, Ms. Zion, can you read for us from remuneration? I will tell you when to stop.
Okay, sir. All right, sir.
Are
Okay.
you there?
The primary, yes, I am. I am here, sir. Okay.
The
The
primary
primary
right.
right, yes, the primary right of every agent is to receive a remuneration for the services that he rendered to the principal. The remuneration of an agent is usually in the form of commission and represents his reward in respect of the duties performed by him. Sorry. The obligation to pay the agent's remuneration and the amount to be paid is usually found in a contract express or implied between the principal and the agent. Where the contract expressly provides for remuneration, the term must be very clear and the agent can only claim in accordance with those terms. So where the agreement provides for the payment of such remuneration as should be deemed right, such a term will be too vague and uncertain to confer a right to remuneration. Taylor versus Brewer. Okay.
Hold on. If you see a quotation mark, you say quotation starts, and when you finish that, you say quotation ends.
Okay, sir. Yes, sir.
So let's go over it again. You said,
okay.
So where provides, go ahead from there.
Okay, so where the agreement provides for the payment of quotation starts, such remuneration as should be deemed right, quotation ends. Such a term will be too vague and uncertain to confer a right to remuneration.
What case is that?
Taylor versus Brewer.
Okay.
Okay,
Brian versus Flight. What does it say?
Okay, but whereas in Brian versus Flight, the agent leaves the amount of payment he is to receive entirely to the principal, it was held that there was an implied term for some remuneration and that the agent could recover on a quantum merit basis.
Okay. In certain profession, for example, real estate, we all know that real estate, the commission is all. Even if the parties don't state it of trade, like real estate, the commission is usually 10%. So even if the agent does natural for the court to imply that commission. So sometimes, even if the agreement does not state the amount of remuneration or it doesn't provide for remuneration, but if it is natural, to pay, the court would imply it. Well, can you go on to the next paragraph?
Okay, sir.
For us, please.
All right. When
Where
nothing
nothing
is
yes.
Yes, okay. When nothing is said on the subject of remuneration, but the nature of the employment and the situation of the is this correct? Of situation of the shows that the payment was intended,
Right.
remuneration will be paid. Okay, remuneration will be paid, and the fact that nothing was expressly agreed is immaterial. Payment will be received on a quantum merit basis, that is, what is reasonable in the circumstances. If there is a trade or other usage or customs which indicates that remuneration is to be paid, the amount of remuneration may be calculated by what is customary in the trade, profession, or business in which the agent is employed. Thus, in Badawi and Elder Dempster Agencies Limited, it was held that where an estate agent is employed to sell property, he is entitled to commission at the standard rates charged by the profession if that is known to his principal. So are you still there?
Okay.
Okay.
I lost
Yes.
you, yeah. So where did you stop? Have you read the Badawi case?
Yes, I have. Yes,
Okay.
I did.
Okay. Another issue is that we want to know when, please note, when is the agent to be paid? At what stage is the agent to be paid? Please, you must know this word. Please, can you write in your notebook, for the agent to be paid, the agent must be the agent must be the direct, effective, or the direct, effective or efficient cause of the event upon which the principal is obligated to pay. So it must not be an incidental act. So please, you must know this in exam. The case of Luxor versus Cooper. Luxor against Cooper. For the agent to be paid, the agent must be the direct, efficient, and effective cause of the event necessitating the agent to pay the remuneration. So, Miss, can you read from even where, Miss Unaram?
Okay, sir. Okay. Even where it is expressly or impliedly agreed by the principal that he will pay remuneration. Another problem which arises is to determine at what stage remuneration is payable. In general, an agent is only entitled to commission or remuneration if he has been the direct, effective, or efficient cause of the event upon the occurrence which the principal has agreed to pay the agent's remuneration. In other words, the agent must show not only that he has achieved what he was employed to do, but also that his acts were not merely incidental to that result, but were essential to its happening. That is, he must in effect have been the means whereby the two contracting parties were brought together and entered into a legally binding contract. But whether in a particular case an event has occurred which entitles the agent to his commission is essentially a question of but whether in a particular case an event has occurred which entitles the agent to his commission is essentially a question of construction of the contract. That is Luxor Limited versus Cooper.
Okay. All right. So for the agent to be authorized to collect the money, it must be the direct, effective, and efficient cause. So you must look for it in exam. Check the fact. Was the agent the one who was directly the cause of the event? Was the one who sold the property? Was it the one who filed the case and argued the case in court? So if the agent was the one who did the act, the direct person, the efficient person, the effective person who caused the act to be done, then the principal is supposed to pay him. Please note, it does not matter even if the principal gets nothing. so far as the agent has done what he was contracted to do, the agent will be entitled to the money. It doesn't matter. For example, if you hire me to file your case in court and I argue the case and you don't win the case, I will still be able to collect my money as your lawyer. So it doesn't matter if the principal doesn't get a benefit. What matters is that the agent has done what he was contracted to do. Okay? So as long as the agent did everything that he was contracted to do, he will be able to collect his money. As long as the agent was a direct, effective, and efficient cause of the act, the agent will be right, can get his money. See the case of Fisher versus Dura. Okay. Another question is if the principal can stop the agent from collecting the remuneration, assuming the agent has done everything that he's supposed to do, and the principal now does something. Maybe the principal now goes now. The principal gives a property to like 10 people and say, get me back. Actually gets a buyer at a good rate. A good rate. Can the second person now to do?
So we can't hear you. Your line is breaking.
Hello?
Your line is breaking, sir.
Can you hear me?
Yes, sir, we can hear you now.
Can you hear me?
Yes, sir.
Hear me? Hello? You can hear me now? Can
Yes,
you
sir.
hear me, please? Okay. Now,
Yes, sir.
okay. So what I'm saying is that
So we can't hear you.
yes, can you hear me? Sorry. Can you hear me?
Yes, sir.
Yes, sir, I can hear you now.
Okay, now, so go on to the next paragraph. It says it is,
Okay.
however.
All right, sir. It is, however, immaterial to the payment of remuneration that the principal has derived no benefit from the agent's acts, as long as the agent has performed what he was employed to do and has not been at fault in failing to benefit his principal. The latter will be bound to pay the agreed commission. See the case of Fisher and Druitt.
Okay, next, let's go to next paragraph.
Okay, a question that arises at this point is whether a principal can prevent the agent from earning his commission. This was the central issue raised by the Luxor in brackets Eastbourne Limited and Cooper and Cooper Supra. In that case, L engaged C to negotiate the sale of property. £10,000 commission was to be paid to C. In quotation starts on completion of the purchase. Quotation ends. Offers were secured for the properties, but the agreement made with the purchasers was expressed to be, quotation starts, subject to contract, quotation end. A binding agreement between L and the purchaser was not completed because L decided not to sell. C sued L, claiming damages for an implied term that L would not, without just cause, do anything to prevent him earning his commission. It was held that C would not succeed because no sale had been effected, and there was no implied term in the contract that L should not act so as to prevent C from earning his commission. Lord Wright exposed the unreasonableness of such an implied term when he said, quotation starts, "It is well known that in the ordinary course, a property owner intending to sell may put his property on the books of several estate agents, with each of whom he makes a contract for payment of commission on a sale. If he effects a sale to the client introduced by one, is he to be liable in damages to all the others for preventing them from earning their commission? Common sense and ordinarily business understanding clearly gives a negative answer. Alternatively, suppose that having employed one agent whose client has made an offer, he receives a better offer from a buyer introduced by another agent and concludes the purchase with him. It seems out of the question that he is hereby rendering himself liable in damages to the former agent. Again, suppose that owing... Okay.
So you can, now the next, so if you see, let me now ask you now, if you, in the exam, if you see subject to contract, what does it mean? Please unmute and answer me. If you see subject to contract, what does it mean? That the principal will pay the agent his commission subject to contract or something like that. What do you think? What will you say? What will you think? What will you say?
Subject to an official contract being drawn up.
What if you see as if, what if you see a quotation that a phrase that says that subject to the principal, subject to what the principal deems right? Hello?
Now we didn't get that part.
What if says that principal will pay the agent subject to what the principal deems right? What will you say? What will you say?
But I think it means that the payments of the agent will be based on the principal's discretion, so he can determine the amount to pay.
Is she right? Hello? Hello?
Sir, please, can you repeat the question?
Somebody's already answering. Why should I repeat? Somebody's already answering. Hello?
Yes, sir, she's right, sir.
Hello? No. Who says she's right? That she's not right? What do you mean she's right?
Sir, we cannot hear you again.
I said, what if we see a clause in the exam that says that the principal will only pay the agent if the principal deems. Can you unmute? We have a long way to go. Can you hear me? Can you hear me?
The line is breaking.
Yes, now.
Okay,
yeah, answer
so
me
your
now.
line was breaking. So your line was breaking. We didn't hear the end of
answer
your
me.
sentence.
Answer me, please. I'm asking the same question I was asking before. The same question. The same answer was the same
Okay.
question I asked before.
Hello, sir. So, in my opinion, I feel like such a contract
Yes.
is as good as gratuitous, because if at the end of the execution of the contract, the principal decides that he doesn't want to pay the agent anything, it was literally in the contract that the principal will pay the agent whatever he deems fit, as there's no
But that,
as there's no as there's no number.
see, you only get 30% of the marks. 30%. You only
Good
get
morning,
30%.
sir. Good morning, sir.
Yes. Go ahead.
Yes, sir.
Yes, go ahead. Go ahead.
He's going to be entitled to.
Who is E?
payment
Who
of-
is E? Who is E? Hey, stop. Don't say E. If it's agent, say
Okay, sir.
don't say E. Okay.
Okay.
Give me your answer again.
The agent will be entitled to payment on a quantum meritorious basis, as stated in the case of Brian versus Flight, sir.
Do you agree with him? Hello? Hello? Hello?
Is it on the subject of the contract, sir?
Oh,
Yes, sir.
can you hear me?
Yes, I can hear you, sir.
Can you hear me?
Yes, sir, I can
Go
hear you,
ahead.
sir.
Any other answer?
Hello, sir. Well, I think the agent could also be
ahead.
entitled to the fixed percentage of
I'm listening.
payment for that like profession, or for the work he has done on the basis of the profession. Like say maybe like the example you gave on real estate basis, where it's 10% of
Okay.
as
All right.
commission.
So the
so
correct
it can be
answer
entitled.
is that general rule. The general rule is that the agent will not be able to collect his commission. However, there are two circumstances. Number one, that the fact that the agent will collect money is evident only based on the quantum merit and depending on the kind of profession in which the agent is. There are certain professions, even if it is not mentioned at all, even if ambiguous words are used, the profession are less. The court will always give you 10% in real estate. So the first rule, the two exceptions to the case. But if you answer only the first rule, you will lose out. Our state, based on the case of Luxor versus Cooper, to contract, the agent will not get anything. Are you still there? Can you hear me?
Yes, sir, but your line is breaking, sir. It is breaking.
Anybody has a question on that? So I can, before we move on. Okay, I'm sorry, my line is breaking today. Does anybody have a question? Do you understand?
I'm sorry,
What did
sir, I'm not
Yes?
clear on something. You said the general rule is that the agent will be able to collect his commission. Is that like an answer to the question of can the principal stop the agent from getting his remuneration?
What is it? No. Not what I said. That was not what I said. I didn't talk about. I never mentioned stopping. Okay? So, anybody actually following the class? That
Sir, your line is breaking terribly, sir.
not
So
what
we
you
can't
think
get
you are
what
saying.
you are
What
saying.
we are talking about. What did I say? What was the question?
Sir, we did not get it. Your line was breaking.
Who is we? Who are we? Sorry.
Okay, sir, I did not get your question, sir. Your line was breaking terribly, sir.
Because at least
I
5
not
people
get it,
answered,
sir.
not we. 5 people at least, more than 5 answered. So it's not that you didn't get the question. You are not here. And I asked the question like 2 times. I said, my question is this now. Can you hear?
Yes, sir.
Sir, your network is still breaking.
It's breaking, sir. It's breaking terribly, sir. It's not. We are not
Sir,
flowing. It's not following, sir.
Can you hear me? Can you hear me?
No, sir.
My
Yes,
question
sir.
is this. My question is this.
Yes, sir.
My question is this. If the principal will pay the agent is called as the principal deems fit, the answer is that the words are too vague. They are too vague that the agent will not be able to get a commission. Generally, the answer is that the words are too vague. However, like we said, there are 2 categories, exceptions. Number 1, if it can be inferred from those words that the issue of payment termination is amount is left to be decided, then the agent will to get his commission based on quantum merit. And second exception is that if the kind of work being done falls into certain custom or trade where it is normally that the amount of remuneration to be paid is very common. It's profession. Then the agent will be able to get his or her commission. Let's move on now. I hope you got the answer now. Do you still have any question? Hello? Wow, today's today. Can you hear me?
Sir.
Sir, please, can you repeat your answer? The line was breaking.
Okay, so let's go on, Miss Uno.
Oh, okay, sir.
20 times. Some people not here. Times. If you said 20 times, we already said in the beginning of this class today, I'm only what Miss Uno read for us. I'm not saying anything new. Okay? So the next issue is that okay.
I'm sorry, sir. Please, I have a question, sir. Hello, sir.
We can hear you.
Hello, sir. Please, I have a question, sir.
Look at illegal contract.
Sir, please, I have a question.
If what the agent has contracted to do is an illegal contract, if what the agent has the illegality was not known to the agent with permission. If what the agent has contracted to do is an illegal, the agent did not know about duty to cure the illegality is on the principal. Commission. Okay. In the case of for example, Haynes versus Boss. The principal was supposed to get a license, but the principal did not get it. And that the agent is entitled to his remuneration because the agent has done all what he was obligated to do. It was for the agent, it was a principal to cure the illegality. Somebody said she asked the question. Who was that? Hello?
Yes, sir. Yes, sir. I was the one. Okay, sir. My question is
What's the question? It's not what you have talked
about. No, it's not what we just spoke about. It was the one we were speaking about before. My question is, if the contract between the agent and the principal says in quote on completion of the purchase, that is the principal would pay the agent on completion of the purchase. If the agent finds a buyer, let's say for a property, but the principal decided not to sell anymore, would the agent still be entitled to the remuneration, sir?
You broke up. I wasn't hearing you. Just go straight to the point.
Yes, my question is that if the agreement between an agent and the principal says in quote on completion of the purchase, that is the principal would pay the agent after the purchase has been completed.
You broke up again. I can't hear you anymore.
First. Can you hear me now?
Please just go ahead, please.
My question is that if an agent introduces a client,
the more you talk, the more I'm not getting you. No, start all over again. Please don't talk in the middle. Just ask the question.
Yes, if the agreement between an agent and the principal says on completion of the purchase, if the principal decided not to sell anymore after the agent has introduced a client, would he still be entitled to his commission?
I think I still don't get that question. I did not get the question.
Sir, I think it's your network that is breaking up from the comment.
Can you instead of telling me story, can you just ask the question?
I said if the agent introduces a client to the principal, but the principal decided not to sell again, would he still be entitled to his commission?
I still don't get it. Are you there?
Yes, sir. I think I'll just type the question in the chat box.
Are you there? Zion,
yes,
are you there?
Yes, I'm here,
Zion,
sir.
are you there?
Yes, sir.
Okay, let's go on to indemnity.
Indemnity. Okay, sir.
Of course, the agent also has the right of indemnity. So, hold on. What we have talked about is remuneration. That is the compensation for the work done. Reimbursement. The first one is payment, commission, which is the remuneration. Is reimbursement. If you are a lawyer now, in this case, you're supposed to be indemnified for the That is what we call about indemnity for the cost which you lawfully incur with the agent while performing the principal's activities. Indemnity, that's being indemnified, being reimbursed for the cost or losses incurred. Please, can you be fast? The network is not good. Indemnity.
Okay, sir. The principal is also obliged to indemnify the agent against all losses and liabilities and to be reimbursed for all expenses incurred in the lawful execution of his duties. Accordingly, an agent may set off the amount of any losses, liabilities, or expenses incurred by him on behalf of the principal, unless the money due to the principal is money which was deposited with the agent for a specific purpose which has failed, or is the balance of money so deposited which remains after such purposes has been fulfilled. The right of indemnity exists whether the agency is contractual or quasi-contractual. Where it is contractual, the right may be expressed, but even if it is not, it will be implied as regards payments made within the authority of the agent. Such payments are not confined to those which the principal is legally bound to make, but includes those which the agent is
All
compelled
right.
to make. Okay.
Yes. So I'm sure you can. So the right of indemnity is different from the right of remuneration. Please stop me if you cannot hear me. Remuneration has to do with payment for the services done for the principal. Indemnity has to do with liabilities or costs incurred while lawfully acting for the principal. You incur some liabilities while lawfully acting for the principal. If you're a lawyer, you have to go to court, file fees, go to Abuja, transport from Lagos to Ikeja, from Yaba to Ikoyi, Federal High Court. So when that occurs, the agent is supposed to be reimbursed. The agent will be reimbursed insofar as it is lawful, even it is lawful for the agent to incur that cost, even if it is not in an agreement. Full and within the agent's duties, what the agent is supposed to perform. For example, if you're a lawyer, you're supposed to get a pay for your photocopy, pay the file cost that are necessary to be in the registry. You're going to pay the filing cost, stamp duty. Those are agent must be reimbursed for those lawful costs performing the principal's instructions. However, there's a right of lien. The third one is a right of lien. Are you there? Can you hear me?
Yes, sir.
Can you hear me? Okay.
Now,
the third right of the agent is the right of lien. It's a claim of right. Some people call it lien. Lien or lien. It's a claim
Please, sir,
of
can you
right.
spell the rain?
What?
Can you spell the rain, sir?
Lien. L-I. Are you not on it? Don't you have the document? It's at the bottom of page 52. Lien. L-I-E-N. Hello? Can you hear me?
Yes, sir. Yes, sir. I got that. I
Can you
got
hear
it. I
me?
got it, sir.
It's at the bottom of page 52. L-I-E-N.
Okay, sir.
Lien or lien. So the agent has the right of lien on the goods that are in his possession. Let me explain to you how it operates. If you have a vehicle belonging to your principal, assuming you're an agent, and the principal is owing you 10,000 naira, and you have a vehicle that is 50,000, you can hold
sir, we can't hear you again.
Sir, we can't hear you again.
Me, what's going on? Sir, we can't hear you again.
Sir.
We can't hear you again, sir.
Sorry, I lost you. So I'm going back again. There are three types of rights which the agent has against the principal. The first one is compensation, remuneration, or commission, the same thing. That is for services performed for the principal. The second one is the right of indemnity. That is the right to be reimbursed for cost or liability incurred on behalf of the principal. The third one is the right of lien, which is the right to withhold a good or chattel that are in possession of the agent until the principal has paid whatever is due to the agent. So there are three things: right of
Compensation or commission.
Sir, it seems we've lost you, sir.
We really have lost him.
Are you still there?
Yes, sir.
I'm very sorry. So we are told right, which is the right of lien. The lien is a possessory right goods in his possession, which belongs to the principal, and the principal is owing the agent certain money, certain claims. So the agent is allowed to keep those property pending the time that the principal is claims. Can you hear me? Are you there? Are you there?
Yes, sir. Yes, sir.
Yes, sir.
Are you there? Hello, are you there?
Yes,
Yes,
sir.
sir. We can hear you, sir.
Okay, sorry. I will continue talking. I will go back again and again so that we can finish this in today. So is the right the first one is that the agent must be in possession of the goods. The agent must be lawfully in possession of the goods that belong to the principal. So once the agent is lawfully in possession, no agreement to the contrary, inconsistent with the right. There's no agreement to the contrary that is inconsistent with the right of lien. And number three, that the goods and chattels were not with express direction to be delivered to another person. So the goods must be in lawful custody of the agent. Number two, there must be no exercising the right of lien. Number three, the goods are not delivered to the agent to be delivered to another. Can lose the right of lane. Are you there?
Yes, sir.
Hello?
Yes, sir. But your network is breaking. Yes, sir.
Hello? Are you there? Can you hear me?
We can hear you, sir.
Hello? Can you hear me?
Hello, sir.
Hello? Can you hear me?
So we can.
Can you hear me? Hello?
Sir, we can hear you.
Hello? Hello?
Hello, sir. We can hear you, sir.
Hello, can everyone hear me?
Are you still there?
Yes,
Hello?
sir.
Yes, sir, we can
I'm
hear
very
you.
sorry. Okay, can you hear me better now?
Yes, sir, we can
Can you,
hear you.
you can
We
hear
can
me
hear
now?
you, sir. Yes, sir. Yes, sir.
I had to log off, sorry, to come back in. Now, tell me, so the right of lien may be lost if the agent loses possession or he makes any declaration showing that he's abandoning his right. Now, the most important one, let's go back to the issue of the first one, the right of remuneration, because that is why the exam always comes out from. There was a lady who was asking a question before. Does anybody have any question on the right of remuneration? Are you there? Have I lost you again?
We can hear you,
Hello?
sir.
Okay. Okay, who has a question on the right of remuneration? The right of compensation, who has a question? Does anybody have a question on the right of compensation, the right of remuneration?
Sir, I was the one asking the question earlier.
Please, just go ahead to your question now.
Yes, sir. My question is that if the agreement between the principal and the agent says on the completion of the purchase, like in quotes, so if the principal eventually decides not to sell after the agent has introduced a buyer, would he still be entitled to his commission?
Yes, based on the case of Luxor versus, no, it will not be. Based on the example, based on the authority of Luxor versus Cooper, if the agent, in the real estate, if you see what Lord Wright said, in the real estate, you don't employ only one agent. You employ like 10, 20 agents to look for the best buyer. So it is now left for the principal to choose the best of the offers. So if agent A, agent number one brings somebody with 10 million, and agent number B, even agent two brings somebody with 20 million, and agent number three brings somebody with 30 million, and agent number four brings somebody with dollars, this bank may choose the one with dollars. So that is the end of the case. So it doesn't have to choose the one that doesn't. So even though the agent has performed, has done everything, brought a buyer, once the principal, once it's real estate transaction, the principal may decide to choose the best, the one that best serves his interest based on the authority of Luxor versus Cooper. But next Friday, we shall look at commission of the real estate. There are other rules that apply to real estate. But at this point we are now, the answer is based on the authority of Luxor versus Cooper, the agent will not be able to collect anything. But if you look at the other authorities that we'll look at on Friday, then the agent might be able, depending on what happens. But the general rule is that the terms in the agreement must be very clear and unambiguous. Then you now see if the terms can be interpreted to a way that will say that the agent will get something, but only the amount is to be decided. Or you will see whether what kind of trade, is it real estate, is it lawyer, is it clearing and forwarding? Then you see the usage and custom in that trade. If in usage and custom in that trade, commission is always paid at a certain rate, then that will be implied because that is what is done in that trade. Then we now go to whether the contract is illegal or not illegal. If it is illegal, the agent will still be able to collect insofar as the issue of illegality was not caused by the agent. Not crime or illegality, like, oh, the person is supposed to get his license and all that. If I'm supposed to come and carry your dustbin now, okay? The owner of the house is supposed to put in certain So I don't know why I lost you again. So, um, so as to indemnity, if the agent is doing everything lawfully and the principal does not, and incurs certain costs and liability on behalf of the principal, it's supposed to be reimbursed. As right of lien, if the principal is owing the agent some money and the agent has certain goods in his possession, the agent may withhold the goods pending the payment by the principal. But if the agent loses possession, the agent loses the right of lien. So there are three rights that the agent has against the principal: the right of compensation, that's the right of remuneration, or the right to commission, that's number one. Number two, the right to indemnity to be reimbursed. Number three, the right of lien. So on Friday, I'll be at university so I can use their internet. Maybe that will be better. But I want us, this area is going to come out in exam or in the CA. Can you hear me? Anybody? Can you hear me?
Yes,
Yes,
sir.
sir, we can hear you.
Yes,
Yes,
sir.
sir, we can hear you.
What we studied today is going to come out either in CA or in exam. That's the right of remuneration. Can you hear me?
Yes, sir, we
I'm
can
lost.
hear you.
So are you going to read it?
Yes, sir.
Yes, sir.
Or you will not read it?
We'll read it, sir. Thank you, sir.
So I want you to go. I want you to go to library. I want you to go to library and bring the question. Do you have the past questions? Do you have the past questions?
Yes, sir.
Hello?
No,
Do you have
sir.
the past questions? Who
Yes,
has
sir.
past questions?
Yes, sir. We
Who
have
has the
past
past
questions.
question?
Yes, sir.
Okay. Can you upload? Do you have a WhatsApp group?
Yes, sir.
Do you have
Yes,
a
sir.
WhatsApp group?
Yes,
The one who
sir.
has, can you upload? Can you upload to everybody so we can look at it next Friday?
No, sir.
Okay?
Okay, sir.
All right.
Sir, we have lost you.
Sir, we have lost you.